So I want to say thank you to the Tla-o-qui-aht people for having us here, and for the great work that they've done over many years protecting Clayoquot Sound and the surrounding areas, and the lead they've taken, really. There's a long history between my law firm and the folks around here, and it will actually be March 27th of this year. It'll be 30 years since for Tsilhqot'in and Tla-o-qui-aht we won the injunction that stopped the logging of Mears Island.
Wow.
So it would be March 27th, 1985, that the Court of Appeal decision came down supporting the decision of the trial judge in that case. So, and that was the moment when BC's then Solicitor General wrote to the judge in the case, Madam Rowles, and said, can we put this in abeyance? We're going to start a treaty process in BC. So that was the day the treaty process started in British Columbia, a week after that injunction win. So the tremendous efforts of the Tla-o-qui-aht and Tla-o-qui-aht peoples really were what made that possible, and it's something that's working its way through today. So Aboriginal Title and Rights, First Nations, and the strongest environmental law in the world, or at least in Canada. And this is what I'm moving with.
Pointed at the computer.
There we go. So before I came to talk today, I just had a quick little look at the province's online map, and I think these are mineral tenures here, right? Just to have a sense of what you're going to be addressing in the years ahead. So whenever you see a big grouping of claims like this, and I see there's one up here in the corner here. This was as much as I could fit into the cadastre map that's available online. But so you have some sense of the things you're going to be facing in the years ahead as these mines come through. At the end of my talk, I'll talk a little bit how, on behalf of the Chilcotin, we've helped to stop a mine, and again with the Tsilhqot'in up further north. So this is what the Chilcotin case was really about. The logging was going on at a tremendous rate in the area. They were bringing the feller bunchers in to finally take out the last of the logging in the heart of the Tsilhqot'in's home area of the Chilcotin traditional territories. And that was back in 1989. So when the original writ was filed back in '89, that was the moment when there was a roadblock, and the Chilcotin had enough and said no. And to get a sense of it, the scale of the logging. So there's the Chilco and Tsilhqot'in rivers here, making this triangle here where you can actually still see forest. The brown stuff is all clear cuts. There was this moment during the trial when a provincial official, he kept this personal diary, and the guy was a real outdoorsman, so he also, he'd take pictures of rock martins and or rock picas and stick them in his journal and write details about it. And there was this moment where he'd gone to hear from the Chilcotin about their plan for sustainable forestry. He'd got some provincial money together to help pay for that, 30 grand or something. And, he drove home afterwards and wrote in his journal, "I'm so pissed off. The Chilcotin have totally screwed me. The sustainable logging plan, it's totally uncommercial. There won't be any logging, blah, blah, blah." When we got that in discovery during the trial, the trial lawyers for the other side, for BC, had blacked out this further statement down below. And so we requested the original diary. And he came back and he'd said, "I'm reviewing some of these old things in preparation for taking the stand in the Chilcotin case, and I realize now that the Chilhqot'in had exactly the right approach. I cannot believe how logging after the beetle kill uplift has devastated the Chilhqot'in and destroyed our forests." So they did, typical short-sightedness, they did 50, 100 years of logging over the next 10 years in response to the beetle kill. Logging over time, which would be if there was 20% beetle kill, you could take the stand, and then it got to be what they called standing green beetle kill to come or something. Mm-hmm. So we work in the area of dealing with Section 35 rights, and this is why Aboriginal rights in Canada are the strongest rights for environmental protections. you've got, for example, the Species at Risk Act out there, and we've done a lot of litigation under the Species at Risk Act, right, trying to force Canada to keep its responsibilities under that act, to do things like protect the caribou in northern Alberta. You've got Eco-Justice down here in Vancouver. They've run cases to try and protect killer whales off the coast. And, you know, at the end of the day, that's legislation, and that legislation can be changed. And that's what the Harper government's been engaged in. They've been hollowing out their responsibilities under that legislation. They've been, you know, the Canadian Environmental Assessment Act has just been gutted under the Harper Conservatives. And what he can't do is change this, right? He can't change the Constitution. He's not going to have any luck trying to do that. So Section 35(1), the existing Aboriginal treaty rights of the Aboriginal peoples of Canada are hereby recognized and affirmed. The result of this has been a great deal of litigation since 1982 while we try to figure out exactly what that means. So we do Aboriginal rights and title litigation. I'm coming to the Chilcotin case eventually. So what happened was here in BC, where there weren't treaties signed, right? There were a few little Douglas treaties on the island, a little piece of the northeast corner of the province. The courts were saying, okay, so what are Aboriginal rights? What do they look like? And they came up with a test for Aboriginal rights. You know, there's a pre-contact practice, custom, tradition, integral to the distinctive culture, reasonably continuous to the present day. And they also started addressing Aboriginal title. And in a very kind of, I think what in retrospect in the years to come we'll look back on it as a very culturally centric view. The court went, okay, Aboriginal title, in order for the common law court to recognize it, it has to look like something the common law court recognizes. So it has to look like fee simple ownership. What do you get to do? What's your right under fee simple ownership? Well, it's keeping other people out, right? It's the exclusive control. It's the right to occupy the land. So what you got was a test for Aboriginal title. I think lots of you will probably have heard of overlaps over the years, right? There's this idea that you can't have Aboriginal title in an overlap area. So in the wake of Chilcotin, lots of nations are trying to negotiate away their overlaps with each other so that that argument isn't raised. But it really, culturally, it just completely destroys all sorts of interesting traditional practices of shared use that have to do with intermarriage and various kind of rights that are earned or gained that way. So it's a real problem. So when a First Nation is not in treaty, right, they have lands that aren't that haven't been ceded or supposedly ceded, and it's not just BC, right? The East Coast has peace and friendship treaties. There are lots of Quebec. Most of the treaties in Quebec are not in force other than the most modern ones. So a First Nation goes to court and says, we have Aboriginal title. The first thing the BC government does is say, prove you're a distinctive Aboriginal group. So prove you exist, right? And a huge amount of time is spent in the Chilcotin case demonstrating that the Chilcotin are a nation, they're a people, they exist, It doesn't matter that Indian Affairs has recognized their existence for 120 years. You go to court and all of a sudden you have to prove that a people is a people. We call it the tedious proof of the obvious. But it's a good example of why these court cases tend to cost a lot of money. There was a great case up in Yukon a few years ago where a lawyer, Steve Walsh, managed to get a report prepared for Justice Canada by an anthropologist, or by Justice Canada for the cabinet, and he got a bunch of little bits and pieces. And apparently, right after the Delgamuukw decision, Justice Canada lawyers were saying to Canada, you need to go file Aboriginal title claims on behalf of the First Nations outside of treaties against the provinces to protect those Aboriginal title lands. You've got a fiduciary obligation to do that, which is what happens in the States, right? All the big U.S. Indian tribe cases, those are all United States of America versus the state of Washington, etc. So in that case, the federal government, taking its responsibilities under the Constitution seriously, goes to court against the state government to protect the interest of First Nations there. Here in Canada, First Nations, with all the financial and social problems that have come from colonialism, end up having to go to court and pay for it themselves, for the most part. In the Chilcotin case, that case happened because we won cost in advance. So the federal and the provincial government had to pay our law firm for the work it was doing for the Chilcotin 50% along the way, of our fees and costs. So that case was able to happen that way. How earlier cases happen, you know, it was bingos and parties and fundraising like this, and the efforts of small groups of people. So the key outcomes of the so Chief Roger came to Jack Woodward back in '89 and said, we have to do something to protect the land. What are we going to do? Choice was made to file a treaty case. I can't say enough about the courage of the Chilcotin people in doing this, how hard it was. Most of the elders, there were 22 elders who came down for trial. Most of them had never been out of the Namaya Valley in their life. Most of them had almost no English. And when they took the stand, they did it. They were translated. You know, I mean, imagine the worst kind of court show television about how brutal and nasty courts can be. The provincial legal council does not go soft on elders in the courtroom. It was a brutal process for them, and it took tremendous courage to do. And the outcome was this, and I'm coming to the bit of why it's such a great environmental protection law. The Chilcotin to the entire claim area, so the claim area is a west and eastern trap line that was registered to the band itself. So the people had all come together, put their trap lines together into these two big trap lines. So there's an eastern and a western trap line. Chilcotin won a right to trap to a commercial level throughout the entire claim area. So they have a right to trap marten, fisher, lynx, you name it, throughout that claim area to a moderate livelihood. No one really knows what that means, but it's more than just subsistence. It's an actual, you know, a middle class living, if you will. The area in darker green is where they won Aboriginal title. And the huge impact of the decision is that when consulting with First Nations about potential developments, the province has always taken the position for the last decade that Aboriginal title might exist to little forest areas or to little village areas, to a salt lick, to a fishing rock, to some small area. Supreme Court of Canada has now said, no, it's broad territorial areas. It can go, even though the Tsilhqotin of the Chilcotin were only about 400 people, they won title to 2,000 square kilometers. And they won it because the carrying capacity of the land required that. So what that land, the number of people it would have been able to provide it for, played a role in the thinking of the court about this. And this is an issue of self-determination and sovereignty, right? How does a First Nation have self-determination? They need a land base to do it from. And this is something that is sort of finally making its way into the recognition of the court. So the judge actually said they'd proven Aboriginal title in the crosshatch areas, but that wasn't actually land claimed in the court case. So for now, a court has found that they proved it. They would probably have to go back to court to say, we proved this, give us these crosshatched areas. So you'll hear lots of talk from mining companies in the province about how the Chilcotin only won something like 5% of their entire traditional territories. This was the traditional territory core area of the Tsilhqotin of the Chilcotin. So they won 5%, or they won 50% of 5% of the entire area. But for the Tsilhqotin, for that little group of 500 people, they won 50% of their traditional territory. So it's a pretty significant win. You know, it's going to be a busy time going forward while everyone figures out what it means. But the court did say some things. You know, they said, oh, we used to always say it's sui generis, you know, it's of its own kind. Now it's just, it is what it is. It's Aboriginal title. It's ownership of the land by the First Peoples that live there. It's the full beneficial interest of the land. It's a right to use and control. It's a right to the economic interest in the land. It means any mines in that territory belong to them now, any minerals, if they choose to use them. It means the future enjoyment of the land, and it means that the province cannot do anything that will interfere with that future enjoyment. So I'm going to talk a little about I think I'm going to skip over a discussion of the duty to consult. I think a lot of you will have heard a lot about it over the years. I'll quickly say, you'll hear a lot about this along with the development of mines and various other things. There are two duties to consult, really, to think about. One is the Haida Nation. So that's where the government is thinking about approving something in an area where a First Nation just asserts that they have traditional Aboriginal title. They haven't actually gone to court. And so in that case, there's this duty to consult that passes through, and the higher the impact, the higher the duty to consult. As the impact gets bigger and bigger, and the Aboriginal right or title is stronger and stronger, you get closer and closer to that consent requirement. But of course, once you actually have title, the Supreme Court of Canada said, look, you might be able to infringe it, but it's going to be next to impossible. If you want to infringe it, you better get consent. So there's strategies for dealing with that consultation process that are really important. And, the major issue for a lot of First Nations is funding and in-house capacity, right? So, if you're First Nation, you've got 3 mines developing in your traditional territory, you're getting 23-inch binders every few months with complex technical details about the mines that are being proposed. And you're getting consulted about every forest license transfer, every cut block, every little piece of development. And these First Nations have, very limited financial resources in their governance. It's basically like they get program dollars. Those program dollars are assigned to do things. And the consultation happens. Someone else wants to come into their territory and develop. And the reality is there's no money that comes for the First Nation to respond to those other people's wish to develop in their territories. So, across the country, First Nations are struggling with this. And the way the law is developed, they can't just refuse to consult or their rights get compromised. They won't be able to go to court later and stop the development. But finding the finances and the ability to engage in that consultation process, it's hard for me to imagine that when the Supreme Court of Canada introduced the Haida consultation process, what they imagined would be that there would be this giant, complex gamesmanship of wealthy companies doing their consultation with small First Nation governments and trying to find ways to overwhelm them and outplay them in a complex legal game. So a mining company has multi-million-dollar law firm downtown Vancouver working on it, and the First Nation is, trying to get the help that it needs, but it's a complex legal game. And the big companies can afford to hire an army of lawyers to represent them in that process. And in that process, because rights and title are asserted but not proven, there is no consent, there is no veto. It's really a process about making development happen, not about stopping development. So it's very difficult to stop development in that process. Duty to consult in the consultation and the justification analysis. So you've heard about since 1982, you can't destroy an Aboriginal right, you can't destroy Aboriginal title, but you can infringe Aboriginal rights, potentially infringe title. And the court, if a government wants to do that, they have to justify it. They have to show that it discharged a procedural duty to consult and accommodate. So if a First Nation goes to court and says, no, we have rights here, what you're doing is infringing our rights, the Crown then responds by saying, look, we discharged our duty to consult, that what we're doing has a compelling and substantial objective, and that it's consistent with the Crown's fiduciary obligations to the Indigenous group. And this is why justification of infringements of Aboriginal title is going to be next to impossible. What the Supreme Court of Canada said in Chilcotin is the compelling and substantial objective must be considered from the Aboriginal perspective. Mm-hmm. So if someone's trying to force a development on a First Nation, and you consider that development from the perspective of the First Nation, are you going to land on this must go ahead? The broader public goal must further the goal of reconciliation. It must actually promote reconciliation. So there's a whole set of comments in the Chilcotin decision at the Supreme Court of Canada that basically says, look, get consent. If you don't have consent, bugger off, your project's not going to happen in an area where title's been proven. So I'm going to quickly move to a discussion about this. So we've assisted the Chilcotin now to stop the Prosperity Mine twice. So this is a mine. This is actually Fish Lake right here that you can see in the background. And this is the island on Fish Lake. It fell outside of the title area. We didn't prove title to Fish Lake, and part of the reason for that is we didn't get a lot of information about this area from the Chilcotin themselves in the run-up to the title trial. The reason for that is that there was a lot of very private information about this area, secret, confidential, spiritual information that was not, they just weren't prepared to make public, even in their own pursuit of Aboriginal title and Aboriginal rights. So it falls within the Aboriginal rights area where they've proven Aboriginal right to a moderate livelihood. But it turns out the island is where they go to get their spiritual, where young men and women go to meet their spirit animals and get their spiritual powers. So it's a lake of incredible importance to them. And when they were finally pushed to the wall, so in 91, Tsilhqot'in Mine started pursuing this gold mine. It used to be that DFO just had a no fish loss policy, right? Mm-hmm. Absolutely zero fish loss. There's a genetic distinct species of trout in this lake. And I don't know if any of you listened to This Is That on CBC. It was like a CBC episode, right? At the hearings, Tsilhqot'in talked about having a big cookout for the Chilcotin, having a big barbecue and inviting people down to come eat all of the fish that they would take from the lake before they destroyed it. Yeah, seriously, this was their proposal. So they went away for a long time, but they came back in full force. There's something like 20 to 30, maybe more $billion in gold and copper underneath the northwest corner of Fish Lake. And their original proposal was to essentially throw a dam up just past where they would put the pit mine, fill the lake and a bunch of areas behind it with the tailings. And it's gold and copper, so the rock that's there is going to be acid generating. And this sits just above the Tsilhqot'in River, right? It's the watershed flows into the Tsilhqot'in River, which flows into the Fraser River, which is, a major salmon source for British Columbians and a major home for the salmon of British Columbia. So they go, originally there's supposed to be a joint panel of the BC Environmental Assessment Office and the Federal Environmental Assessment Office because it affects waters which were under federal jurisdiction. The feds would have to be involved. So there was supposed to be this joint panel doing the environmental assessment. When the Chilcotin, who were trying to be nice in the consultation game, finally had to say, no, you're not going to do something that's going to destroy this lake, they split it off. BC took off and said, no, you know what, we're going to do our own assessment. In the space of 6 months or 8 months, BC's Environmental Assessment Office said, yeah, it's fine, go ahead. Canadian Environmental Assessment Panel took about another year and a half, 2 years, came back, said, nope, this mine is going to impact an area of too much spiritual importance to the Chilcotin. It's outside, remember, it's outside of the title area. It's in the rights area where they won Aboriginal rights and proved them. But it is outside the title area. And the Environmental Assessment Panel said no. They came back and said the impacts of this project are too huge, and they rejected them. So, of course, in the last couple of decades, the way the Canadian Environmental Assessment Act works is all that panel does is make a recommendation to Cabinet. And so Cabinet, Prentice at the time was the Minister of, I think he was Industry Minister, and he was responsible for making a recommendation to Cabinet based on the outcome. He recommended against it. Cabinet did turn it down, so they agreed with the Environmental Assessment Panel, said no, and what's his face? Prentice left office the next day. So, we'd all love to be a fly on the wall and understand and know what went on in that cabinet room, but that was how that played out. So they go away. They get told to go away. You're out of luck. They come back a couple of years later, and their proposal, we have a new proposal, and their new proposal is one of the proposals that in the first time they went to the Environmental Assessment Panel, they said, under no circumstances could we use this other proposal. It's not financially viable. They come back to take another run at it, and they have this one that they previously told the panel was not viable, that they couldn't possibly use. They come back with exactly the same proposal. Environmental Assessment Panel turns it down again, and it's right in the kind of heat. The heat's just starting to come off the Idle No More movement at the time. And so it's kind of perfect timing, and Harper agrees and rejects the mine again. that the company is now suing the federal government in a couple of legal actions, saying that they've made the wrong decision. So this carries on, and I'll come to this thing in a sec. So the outcome really for the Chilcotin, the whole process of the rights and title case did a bunch of really interesting things. It brought a lot of information together, right? They got really organized with their rights and title information, so they were able to go to the environmental assessment panel with elders who were keyed up and ready to go give evidence. They had lots of evidence of what the impacts on their rights and title would be. They also, what happened in the rights section of the case, people talk about the title aspects of the Chilcotin case. But what happened in the rights section was the court said, look, they've got a right to hunt, trap, and fish to a moderate livelihood. We don't know exactly what that means, but if you want to go do any development in that territory, you got to figure out how many marten, fisher, lynx, mink, ermine, how many the Chilcotin need in order to practice that right. You go to figure out how many they need. You also have to figure out what intact forested area is necessary to ensure that there is a harvestable surplus of those species, right? There can't just be a healthy population. There needs to be a population that is so healthy that there's enough marten, fisher, lynx, mink, ermine, bear, whatever, to be hunted and trapped to make that moderate livelihood. And what this means is that the Aboriginal right to trap is an environmental right, because it means you have to protect those huge swaths of the boreal forest in order to ensure that that right is practicable, and that is constitutionally protected, right? The highest law in Canada, any law or action of government that happens under that goes against the constitutional principle is not a legal activity. And this has happened in Canada before. During the Great Depression, I think it was Saskatchewan or someone tried to get into banking against their constitutional powers. Am I being told how are we doing for time? I should shut it down. And one of the provinces had tried to do a bunch of banking thing, and they printed their own banknotes, and that was a federal power. And the courts came along and said, no, you can't do this, and tossed all those laws. So, the only thing that prevents First Nations from being able to protect their territories is the financial cost of going to court. But there's a huge impact on communities. That's changing over time. The federal court is taking on rules for cross-examining elders and things like that. So there are, in fact, efforts being made to make those venues more hospitable. I'm just going to make a couple of quick recommendations, specifically for Friends of Clayoquot as you go forward. There was a movie made called Blue Gold, the Chilcotin Fight for Tsimini. The entire thing is available on Vimeo. And we worked with the Tsilhqot'in on the Amaze, a mine that was proposed for the Amaze, again, a lake to be destroyed, a film about water, another wonderful case. So thank you again for having me. I hope I've given you some sense of the power of the environmental laws that First Nations have at their fingertips. It is a deeply troubling circumstance that these communities that have suffered so much under colonialism and residential schools and all of the fallout from it, they're now the bodies we turn to stop tar sands, to stop the mines, to protect the lands we all love. And it's them that we turn to ask them for their help. So the work that's been done over the years to protect Clayoquot is amazing. And I want to thank Tla-o-qui-aht and House It Again for all those efforts. And thank you so much for having me.
Hold on, 2 seconds.